over 600 milligram per kilogram. It's not material to anything and didn't change the chart, but it was in the footnote. So I think that's the only, I endeavor to be accurate in my report. I think that's the only correction I have.
So that would be a footnote to the table regarding the soil conservations has a note that it the highlighted area is 300 milligrams per kilogram.
It's presented as table 1 in the report, and the footnote shows dark blue equals over 300 milligram per kilogram. It was actually dark blue is over 600 milligram per kilogram. And so that was just an error in the report.
So if you change that number in the footnote from 300 to 600, then that would be a correction. Okay.
That's correct.
Thank you. Okay.
Mr. Grams, do you adopt your report under oath today?
Yes.
Okay. Thank you. All right. I'm not sure who should, I mean, normally I would go to Mr. Hall, but we also have Mr. Smith as well. Mr. Hall?
I have no preference, whatever pleases you.
All right. Mr. Smith, are you ready to cross-examine this witness?
Yeah, I have a few questions.
Go right ahead.
Okay. Thank you, Mr. Graham, for being here today. First and foremost, based off of your exhibit, it was the 5th point, I believe, on the next slide. And it was also mentioned in exhibit B2. TMW7 and TMW8 are in the suspected release point and in the release path, correct?
That's correct.
And based off of your slide of the 5th point, that had chloride impacts from the top of the Vado zone to groundwater. Is that correct?
TMW7, no, there was no, actually, they did not collect soil data when they drilled TMW7. So the area of TMW7, that's not correct.
About 8.
Well, again, the soil data was from borings, not from drilling TMW8. So I can't speak to that. It's in that area.
Yeah. Can we pull up slide number? It was the 5th point in your slide presentation, the one with the blue data that was hard to see.
Did I? You probably zoom in on the columns to the left, maybe. Is that what you're looking at?
Right. Yeah. So SP5, borehole 7, right? This is the area that is relative to that area. And this shows elevated impacts from 0 to 45. Is that to the right? I can't see it, but.
Yeah, those are the borehole 7 and borehole 8 don't correspond with MW7 and MW8. They were different holes drilled independently at a different time.
Yeah, sorry, I'm just looking at the map from your other borehole because I might have misplaced those.
So, yeah.
Okay, I'm just going to go with my notes that I have here from when I was reading it, not off of the slide that you presented.
Yeah.
Because I didn't actually have that. So, but TMW7 and 8 did have elevated levels of contaminants of concern in them at sampling points at one time. Is that correct?
I have never seen any soil data from either of those wells.
In the groundwater.
In the groundwater, yes.
And they're and those 2 wells are in the release path.
Yes. But they're low. They're much, much lower than anything that you see in the center.
Right. And so on page 980 of your exhibit, you do kind of make that statement that the wells are decreasing, and it's likely indicative of the remediation that Apache did and the installation of the liner, correct?
I did say that, yes.
Yeah. So based on that conclusion that there was remediation and that the liner is there, wouldn't you agree that the groundwater underneath that particular area was likely impacted by the July 14th, 2019 release?
Yeah, it's hard to say where that came from, but that would be reasonable.
Okay, and then regarding SB2, in your presentation and your documents, you guys, Apache proposed that there was other sources that could potentially be leading to the elevated chlorides or impacts in the area. My question is that SB2 is down gradient of the generally area that is considered to be high, which is TMW 17, 34, and 31 roughly, right? Or sorry, 36.
That's correct.
How did you determine that that would be a potential source for that area?
Well,
If
you know,
it's
one of the technical papers that I reviewed talked about how a plume of chloride can sink and follow the topography of the basal unit in the aquifer and move in different directions that are not expected. So it's referenced, and it's a paper that the situation out here is that the Triassic red beds are an erosional surface, and we don't know what the topography of those things look like. But we do know that the aquifer is sitting on top of that. And so it's very possible there's some topography in that Triassic surface that is controlling chloride. And, you know, chloride is a conservative mineral, or anion with doesn't break down over time. And so it's very possible that it migrated deeply along the base of that unit. So that's the only, yeah.
Okay. Thank you. On page 981 of the Exhibit B2, it's section 4.3 where you talk about the Mann-Kendall trend analysis. My understanding of your section, and I think you guys have pretty much hit on this as well, is that you've essentially concluded that this plume is stable in the sense that most wells are not trending or up or down, right? It's relatively stable. Is that correct?
That's right. Right.
The Mann-Kendall trend analysis, though, doesn't necessarily identify a source of contamination or if there's any other type of contamination elsewhere on the site. Is that correct?
That's correct.
And I think Mr. Molenberg kind of already explained this, but I guess just for my sanity here, based on your review of the elevated levels of contaminants of concern in groundwater in this area, I'm not saying necessarily from the release of July 14th, but in your professional opinion, there is elevated levels of contaminants of concern in this area from likely oil and gas activity?
I would agree with that, yes.
I don't have any more questions,
Mr.
Mr.
Hall,
Hearing Examiner.
thank you.
I have a few, thank you. Hi, Mr. Grams. My name's Michael Hall. I'm an attorney with the Oil Conservation Division. Thank you for being here and thank you for your attention to this important matter. Can Apache determine when this contamination occurred?
We have not done that, no. I'm not saying that they could not, but we have not.
That have not.
Have not.
Okay. And same for how this contamination occurred. Apache has not made that determination, correct?
I assume you're referring to the bulk of the plume,
I'm talking about, well, it might help if I pull up. Might take me a sec. I wasn't planning on pulling this up just yet, but yeah, well,
yeah,
sure. Really any contamination and above acceptable limits for any of the monitoring wells. Has Apache made a determination how that contamination occurred?
no, they have not.
and even though the monitoring wells are noting elevated levels of contamination, has Apache determined where, similar to how, we don't know how, they don't know where the event occurred that caused that, correct?
Well, it's hard to draw a direct line from the event in 2019 to what we see. That was my whole point, is I can't draw that line. So the acting assumption is that there's historical operational issues out here in this oil field that have caused that massive plume.
And you would agree that was there in 2019?
Yeah, I believe it was.
Okay.
Yes.
Think I asked something similar to this, but has Apache to your knowledge, undertaken any steps independently to determine the source? And if I think you said no, so why not?
Well, I can't speak to what Apache has done on that. They've engaged me to do the environmental investigation, but in terms of what else they may have done, I don't have visibility on that.
Fair enough.
Yeah.
Do you were part of the commission's hearing in early 2025, correct?
That's
You
correct.
testified?
Yes.
Do you dispute the commission's finding that Apache cannot explain or identify the source of contamination causing the exceedances of chloride and TDS from samples within the impacted area?
I think that is probably correct. That's pretty much what I've said too. Yeah. Yeah.
I think you have. I
Yeah.
just
I'm with
want to
you.
make sure you agreed with the commission's findings there.
Yeah, I think so.
And again, okay. Let me go to next finding there. Would you agree with the commission's finding that Apache cannot estimate the volume of produced water necessary to cause the level of contamination observed in the groundwater samples?
I'm not sure how to answer that question. I provided an estimate of what I think the chloride concentration is there, or the mass of chloride there. I'm not clear on the question, I guess.
Sure, okay. Another finding is Apache cannot explain or estimate the release volume causing the spike in samples taken in October of 2024. Do you dispute that statement?
No, I don't know. Again, that's an operational issue with Apache and how they track their products. And so I don't know that.
Would you agree that's exceptionally difficult to pinpoint the sources of contamination?
Yes, I would agree with that.
Do you have any familiarity with the history of ownership or operatorship of the land in question?
No, I don't. No, that's not my area.
Sure, I understand. Just
Yeah,
making
yeah.
sure.
Yep.
Certainly in 2019, Apache controlled that location, correct?
It's my understanding.
You have no reason to disagree with that statement, do you?
No, I don't.
Are you familiar with a closure report? I think it was in your report. Certainly it's in Apache's evidence regarding the soil contamination.
I have seen that report. It's a December, or well, maybe it's March of 20. Anyway, yes, I have seen the report.
Okay. And did you see that with the checklist for closure, a notation was made that this is for soil remediation only, still conducting groundwater monitoring? Did you see that?
I don't recall, but I would have to review that report again.
Sure. And that would be submitted by Larry Baker in February 9th of 2021, page 29 of Apache's evidence. And so that would comport with in fact, the need for continued groundwater monitoring, which occurred after 2021, correct?
Object to the question. I think what he's saying is the report speaks for itself, but Mr. Grams has indicated that he's read the report. He's not real familiar with it. So I don't know that it's fair to ask him a question on characterizing the report that way.
Mr. Hall.
Yeah, I would ask that he answer it instead of Mr. Mullenberger. If he doesn't know, he can say that.
There's an objection. So we have to deal with the objection.
Yeah,
So what is your
the objection is Mr. Mullenberg's speculation as to what this witness does and doesn't know isn't relevant to this. What the witness knows and doesn't know is important.
Mr. Hall, is this part of the scope of this witness's testimony?
Yes, it's about closing the soil remediation and groundwater monitoring continuing. I think that's, I do think so.
Mr. Molenberg, if it's within the scope of the direct testimony of this witness, how is it not a fair question?
Mr. Hearing Examiner, I don't recall that Mr. Grams spoke very specifically to the soil closure issue, but I mean, with everything that's been said, I think if Mr. Grams can answer the question, we'll go ahead.
Okay, so I'm overriding the objection. Mr. Graham, can you answer the question?
The report was prepared by a different consulting firm 3 years before I got involved in the case. I've reviewed it. We pulled data out of it for some of our analysis, but I don't remember the details of some of the text and the forms that went with it because that really wasn't my focus. So I really can't speak to that.
I'm pulling up, again, page 29 of Apache's own evidence. Do you see down there that it says this is for soil remediation only, still conducting groundwater monitoring?
I do see that.
You have no reason to dispute that's the case, correct?
I have no reason, no.
And in fact, that comports with what happened after, when you became involved, groundwater monitoring continued to occur, correct?
That's correct.
Do you have any opinion as to who or what is a responsible party or responsible person under the pertinent Oil Conservation Division rules?
I really do not. I'm not a legal expert on that.
Fair enough, and
Yeah.
I'm not asking you to opine on that. I wanted to be sure you weren't going to.
Yeah, no,
Okay.
I'm not.
I think this will be similar to your last answer, but certainly would like your commitment on this. Do you have any knowledge of the purported transfer and the details of that from Apache to Hillcorp of the relevant locations?
No, I do not.
Okay.
I've not been involved. Yeah.
I'll pass the witness.
Mr. Molenberg, any redirect?
Briefly,
Go
Mr.
ahead.
Examiner. Mr. Grams, do you recall Mr. Hall's questions to you about findings in the commission order to the effect that Apache had not been able to identify specific sources of groundwater contamination?
Generally. Yeah.
Okay. Is it fair to say that based on your expert opinions, you believe you can rule out the 2019 release as a source of the larger area of groundwater contamination?
I believe that was, the whole point of my report. Yes.
At the time of the hearing before the commission, did you have sufficient information for you to rule out the 2019 incident as a source of the larger area of groundwater
We did
contamination?
not have anywhere near the amount of information, so that was not something that we had done, no.
Okay, that's all I have.
All right, thank you. May this witness be excused? All right. You want to call your second witness?
Yes, Mr. Examiner, Apache calls Barrett Bowl. And Barrett Bowl will be appearing
I see him.
on the platform.
Thank you. Mr. Bo, I remind you that you're still under oath.
Yes, sir.
All right, and please try to speak, since you're remote, please try to speak loudly and clearly so that the AI can pick up the transcript. Go right ahead, Mr. Mullen.
Thank you, Mr. Examiner. Would you please state and spell your name for the record?
My name is Barrett Boll, B-A-R-R-E-T-T. Last name is spelled B-O-L-E.
And who is your current employer and what is your position?
I'm employed by Apache Corporation as an environmental advisor.
And how long have you worked for Apache?
Almost 14 years.
Okay. On whose behalf are you testifying today?
On behalf of Apache.
And did you provide a resume admitted as Exhibit C1, which provides additional details regarding your employment history, qualifications, and experience?
Yes,
And you're here today as a fact witness, correct?
that's correct.
Okay. Mr. Bull, what are your responsibilities with respect to the East Blindbury Drinkard Unit number 37 well, particularly as it relates to the 2019 release? And if you could, as you answer that question, describe when your involvement began.
So previously, environmental activities in New Mexico were under the guidance of Larry Bruce Baker, whose name came up just recently. He responded to the original spill that happened very near the surface at a 90-degree turn in a injection well feeding the Ebdu 37 well. There was a large area that was affected. You can see with the soil data, a lot of that didn't migrate in too deeply. He got that one, a lot of it dug and hauled, a liner installed. I wasn't really involved in any of that. I didn't review the report. I just knew of its occurrence. And then he was asked to start installing monitoring wells. And I became involved in July of 2023 when I think we were on our 7th monitoring well, and the data started to look awkward to me from its proximity to the location of the spill as to the results we were seeing. And at that point, my expertise was in groundwater remediation, and so I kind of stepped in and started moving the project into my, I guess, under my direction.
Mr. Ball, I may have misheard you. I think you said maybe my area was not groundwater remediation. Did you perhaps mean Mr. Baker?
Sorry, Mr. Baker's was not groundwater remediation.
Thank you. Mr. Ball, have you examined Apache business records, and are you familiar with the period when Apache was the operator of the EBDU number 37 well and the associated unit?
Yeah, I reached out to our land department to get those records as close as I could, and looks like we took ownership of that lease and area November 1st of 1998, and we divested it to Hillcorp on December 31st of 2024, although there was a active date of July 1st of 2024. But we operated the lease up till 12/31/24.
Okay. Is Apache the current operator for the EBDU number 37 well and unit?
No,
Was it an operator at the time of the March 12th letter?
no, we were
March
not.
12th,
We had
2026.
divested to Hill. Yes, no, we had, of 26, no, we were not.
Okay. Does Apache have any ownership interest in the EBDU number 37 well and associated unit?
We do not.
Do you know from whom Apache acquired its interest in the late 90s?
It was from Conoco.
Okay. You mentioned the transfer from Apache to Hillcorp, and when that occurred, I think you mentioned something about a delay in the effective date. In that regard, are you referring to the transfer as operator of record?
Objection leading.
Mr. Molenberg, would you rephrase the question?
Okay, yeah, I'll try to. I was just trying to catch him up on what I'm trying to clarify here.
Well, you can orient the witness, but
Yeah,
that
yeah.
wouldn't be part of the question.
Yeah.
So go ahead.
I'll do it a different way. Mr. Bull, are you familiar with Apache Exhibit A3?
I know it exists. I'm not very familiar with it.
Do you know whether that is the record of the transfer of operator of record for the EBD number 37, EBDU number 37 well from Apache to Hillcorp?
Yes, it is.
Okay.
Excuse me for a moment. I have a light sensor. There we go.
So when did Apache receive notice from the division that the division was requesting an abatement plan pursuant to 19.15.30 in MAC?
That letter arrived via email on March 12th of this year, 2026.
And is that exhibit A1 in evidence?
Yes.
And did Apache prepare a written response to that March 12, 2026 letter?
We did provide a response.
And is that response in exhibit A2?
Yes.
And what was the date of that response? Do you recall?
Yes, it was March 31st of 2026.
Can you provide a summary of the position Apache took in response to the division's March 12th, 2026 letter?
Yes, Apache's position was that we were no longer the owner or operator and therefore could not be considered a responsible person because we didn't meet the definitions. Also, the notice letter from the district was very vague in many respects. It just said oil and gas historical operations, which could be anything from the original operators up to the current operators, alleged to be the source of the groundwater impacts. It also did not address any of the additional potential sources that we had put in our field activity reports.
Thank you, Mr. Bowl. And does Apache, as we sit here in the hearing today, continue to oppose the requirement for Apache to submit an abatement plan under 19.15.30 in MAC?
Yes, we do.
And can you summarize for the hearing examiners the reasons for Apache's position in that regard?
Well, fairness, first of all, it appears that we're being asked to take responsibility for groundwater contamination that may not even be associated with our 2019 pipeline release or any of our operations, which again occurred from 98 till the end of 2024. And the data we collected as a result of additional groundwater monitoring ordered by the commission has allowed more detailed analysis.
I object. He's reading off something and I would like to be able to see it. I don't think he's reading something instead of testifying to his opinions.
Mr. Molenberg?
Mr. Hearing Examiner, I don't know what Mr. Bowl is reading from. or
Well, let's
whether
find
he's
out.
reading from something or whatever. So
Let's find out. Mr. Bowl, are you reading something?
I am. I'm reading some notes that I typed up.
Ah, okay. Mr. Bowl, since those notes were not shared with opposing counsel, I would ask that you testify from your own personal knowledge and not from notes that you prepared. If you can't do that, then we'll have to go through the process of sharing those notes. So can you testify from personal knowledge?
Yeah, absolutely.
All right, so if you'll put those away and tell me that they're away.
They're away.
Okay, thank you. So, Mr. Mullenberg, would you ask the question again?
yes. I believe the question in front of Mr. Bowl is why does Apache continue to oppose the requirement to submit an abatement plan?
And again, we don't feel that we're now considered the responsible person based on the fact we're no longer an owner or operator. And also, John Graham's testimony demonstrated that this plume is a much larger mass of contaminants that could be associated with the 2019 spill. And for those reasons, and from the discovery of a potential disposal pit that did identify contaminants all the way to groundwater, that was operated for a long period of time based on aerial photographic imagery, we just believe that that is a more likely source of the contaminants than, you know, the chlorides that were released as a part of our 2019 release.
Thank you, Mr. Bowl. Do you have anything else to add to your testimony today?
No, not at this time.
Thank you, Mr. Examiner. Mr. Bowles available for questioning.
Mr. Hall.
Thank you. I don't know if Mr. Smith, if did we want to go on?
Mr. Hall.
Oh, thank you. Are you familiar with the details of the transaction transferring this property from Apache to Hill Corp?
I am not. That was between land and legal.
So you don't know, for instance, if there's a joint defense agreement?
No, I do not.
You don't know if there's been discussions about Hill Corp not appearing in this case between Apache and Hill Corp?
No, sir.
You don't know or not know. You have no knowledge. Is that correct?
Yeah, I have no knowledge of that document.
Do you know if there's an indemnity agreement relating to contamination one way or another?
No, I do not.
Do you know if Apache has independently investigated the source of contamination that is showing up in these test results?
The only additional investigation that was done while we were in the process of agreeing to the installation of the 15 additional wells and the 2 soil borings was the discovery of aerial photographs, which did show historical disposal pits on the lease. To the southeast, I believe, of the source area of our release, and to the southeast, more than 1,000 feet, a long ways away.
Would you agree that Apache is responsible for all contamination on the relevant property during the time of its custody and control of the locations?
Objection calls for a legal conclusion.
I'll sustain that. Mr. Hall, would you rephrase?
Sure. Does Apache take responsibility for the contamination that was on the land it operated?
Apache did the soil remediation and received closure on that from the 2019 spill. If it could be ascertained that the 2 areas where there was deeper leaching of chlorides could have contaminated the aquifer, then yes, we would be considered responsible for that small area.
Was there any evidence in this case that Apache is not responsible?
Yes, I believe Mr. Graham's testimony demonstrated various factors that would suggest that we are not responsible for this larger plume that exists.
Would you agree he testified that Apache can't determine when, how, where, or what caused the contamination?
I would agree that we can't 100% determine that cause, but I do believe we have evidence of, again, a disposal pit where produced water was placed into for more than 15 years as part of allowable operations at that time.
Well, Mr. Graham's testimony and report speaks for itself. You're not holding yourself out to be an expert witness on causation of the contamination, are you?
No, I'm
Okay.
just, yeah.
Well, I would ask that last answer be struck
On what basis?
on the basis that he's trying to give expert testimony about the contamination and the cause.
Mr. Bowles is not a expert. He has not been recognized as an expert. He's a fact witness. Anything he says is seen through that lens, and and I will put whatever weight I think it is deserved of.
Thank you.
Are you finished?
No.
Okay.
Was the chloride contamination observed while Apache had custody and control of the sites?
Objection just to the form of the question. It's pretty vague about when he says the chloride contamination.
Mr. Hall, would you rephrase the
Sure.
question?
Was all chloride contamination observed while Apache had custody and control of the site? Was that observed?
No, not all of it. The last 15 wells and the 2 soil borings where we discovered more contamination spread outward was while Hillcorp was the operator of record.
Do you dispute that chlorides were observed in excess of allowable limits in the groundwater sampling that occurred while Apache had custody, control, ownership, and operation of the sites?
Can you reword that question?
Do you dispute that there was chloride contamination in the groundwater when Apache was operating the property?
No, I do not dispute that.
Do you have an opinion one way or another about whether Apache inherited, for instance, you're claiming Hillcorp's responsible for the contamination now. Is that your position?
No, that's not my position. My position is that we are no longer the owner or operator.
Well, when you were testifying about your response, I believe you said you thought Ms. Romero's notice was vague. Was there another reason you gave why you shouldn't abate, be subject to the abatement plan?
No, I just believe that we brought evidence of potential other sources that might have contributed, and that information was overlooked in the review of that report.
Is that based on Mr. Graham's report?
It was based on the field activities report that was submitted to the NMOCD.
That showed contamination of the groundwater?
No, I'll clarify, that showed that there was other potential sources for the contamination. There's no disputing the ground. I'm sorry, there's no disputing the groundwater is contaminated.
And was contaminated at the time of Apache's operatorship, correct?
Yes.
You're simply disputing that the chlorides being found in by the monitoring wells, you're disputing that was caused by the 2019 release, the pipeline, correct?
That's correct.
And you have no opinion as to any other certain sources of contamination. You're speculating that it could have been from a pit from decades ago.
No, I'm not speculating that the pit existed. It did. It's visible in aerial photographs.
It existed, and you have no idea whether it caused this contamination or not, correct?
I could only go on John Graham's testimony that the soil boring drilled through it showed chlorides from the top all the way to the base.
You're not disputing his testimony that he can't determine when, how, where, or what caused the contamination, are you?
I'm not disputing that.
Okay. And you're not here to provide any testimony about the applicability of the relevant rules on Apache's responsibility for this or not, are you?
No.
Okay. I'll pass the witness.
Mr. Smith?
Thank you. Good afternoon, Mr. Bowles. I'm Corey Smith.
Good afternoon.
If since there was no written testimony, I was trying to write down notes as fast as I can. So please correct me if I say something incorrect here. But you were an environmental advisor of 14 years for Apache. Is that correct?
Several titles, but that's the most recent one. Yes.
Fair. And I believe you said that Apache took ownership of the lease roughly in November of 1998 and operated it to December of 2024.
Yes, that's the approximate date range.
Right. And prior, the sale to Hillcorp was of June of 2024. Is that correct?
I think it was July 1st.
July of
The
2024. Though.
The effective date was in the summer sometime of 2024.
When was the transfer of the lease and the wells approved by the OCD?
I believe it was in late March.
Was that after or before the letter was sent? The abatement letter that Ms. Rosa Romero sent?
I do not know. I do not know the exact date of the transfer, but I believe it was in late March of 2025.
Mr. Mullenberg, do you have the exact dates by any chance? Is that, can I ask that question to him?
Well, I can refer you to Exhibit A3, and I would just note that there may be some misunderstanding here about whether we're talking about March of 2025 or March of 2026. I think you're speaking to the March 2026 letter from OCD.
Correct.
Okay.
And yes, then Hillcorp was the listed owner on the website in March of 2026. I got my Marches mixed up.
I may have got my dates mixed up with that question as well. Okay, thank you. Okay, as an environmental advisor, would you say that it's pretty common practice to do due diligence before acquisitions of wells?
I would say yes. In current times, I would say in 1998, oil companies probably didn't do a lot of that.
So you, because you did say that you reviewed Apache's notes of operations prior to this, and you didn't
Yes.
you didn't discover any due diligence or talks about
No,
environmental issues.
no, I did not.
While reviewing those records, was there any type of discussion about retaining environmental risk or not being responsible for any type of operations that occurred prior to the acquisition?
I don't have any knowledge of those documents.
Okay. And I think this is similar to what Mr. Hall asked you, but I am not a lawyer, so I don't know exactly what a defense agreement is. So I'm going to use the terms that I understand as an environmentalist. Was there any agreement prior to the sale of these assets between Apache and Hillcorp to retain any environmental risk?
That I do not know, but I am aware that all of the other environmental projects that were ongoing did transfer into Hillcorp's hands.
I don't have any further questions.
Mr. Mullenberg, redirect.
Briefly, Mr. Examiner, Mr. Bull, Mr. Hall asked you a question about Apache's investigation of other sources of contamination. Do you recall that?
Yes,
And I believe that you mentioned that there was at a point in time when Apache learned of a disposal pit.
that's correct.
And can you clarify the time frame that occurred?
The aerial photographs were obtained in early April of 2025.
Okay, thank you. Mr. Hall also asked you if there was contamination at the time of when Apache was the operator at this site. Do you recall that?
Yes,
Just to clarify your answer to that question, when you were asked that question, were you thinking of whether contamination existed or whether contamination occurred during Apache's period of operation?
well, the contamination existed.
Thank you. That's all I have.
May this witness be excused?
Yes.
Do you rest your case?
We do, other than as we get to the end of it, we would like to discuss closing statements and such. Yes.
I was just talking about your case in chief. I understand that something may arise.
Yes.
That might
Yes.
cause a rebuttal case or.
Right. Right. But yeah,
Your
for
case
our
in chief.
direct case, yes.
Sounds good. Mr. Hall, who do you have?
Ms. Romero and Ms. Hall, but I would ask for just a brief recess.
Sure. I mean,
I need to use the restroom to be
no,
specific.
that's fine.
Okay.
That's fine. I mean, I've been sitting here all day myself. So 5 minutes?
Sure.
Great. Go right ahead. Mr. Molenberg, are you ready? Okay, we're back on the record. It's 3:11 and the New Mexico Oil Conservation Division is going to put on its case in chief. Mr. Hall, who are you calling first?
Call Rosa Romero.
Mr. Romero, I remind you that you're still under oath. Go right ahead.
Thank you. Could you state your name, please, ma'am?
I'm Rosa Romero.
And how are you employed?
I am the Environmental Bureau Chief for OCD.
And how long have you been in that position?
Approximately 4 years.
And in fact, in further detail, you've submitted your curriculum vitae, which has been admitted into evidence. Is that a true and correct copy of a more detailed account of your employment history?
Yes, it is.
Thank you. Generally, I think it would be helpful to kind of go through the regulatory framework for this sort of situation. And so basically, if you don't mind, could you enlighten the hearing examiner as to what generally happens when a release occurs and is reported by an operator?
Absolutely. I may refer to the rules. I do have my rules on screen if you would like to bring any of those up, but explicitly the rules.
I should be able to pull those up. Are they generally in part 30, part 29, and maybe in part 2?
Yes.
Okay, I can pull those up if that would be helpful.
I'll let you know. I'm just gonna kind of run through and if you need specific stuff, I am probably reading a little off the rule.
Sounds good.
Mr. Examiner, but before we start this, and I don't want to do a bunch of objections, can we clarify whether Ms. Romero is a lawyer and she's being asked about legal opinions, or she's been, to the contrary, which is fair from my standpoint, if she's being asked about the department's interpretation and application of the rules as a regulator?
We stipulate she is not an attorney and is not giving an opinion an attorney would give. However, she is the environmental chief for OCD and has great familiarity with the applicable rules and regulatory framework, and we intend for her to testify about that if you so allow us.
Gregory, your microphone's muted.
Thank you, Mr. Smith. I appreciate it. What would be helpful for the hearing officer at this point is to understand the rules and regulations that control the case as it stands now. But from your own perspective, Ms. Romero, I'm not asking you as a lawyer to explain it to me. I can figure that out myself, but I'd like to understand how the division is enforcing this rule and its practices behind that, if that helps you.
It does, absolutely. I will stick to more of our process versus legal.
So I don't really need to see the rules on the screen unless Ms. Romero needs that for some sort of reference.
She may refer to rules, I assume, correct?
Of course
Okay.
she may. Of course, they're here.
That was just my warning that is what I have up on screen, so.
Go right ahead, Mr. Hall.
Yes, I believe, Ms. Romero, my first question is, when a release occurs and is reported to OCD, what happens at that point?
Our release system we use is our 141 process, both for soil remediations and groundwater remediations through our e-permitting process on our website. It is kind of important to note that Part 29 and Part 30 are individual rules, and we treat them for the most part as individual rules. However, we are using the same mechanism, and they do relate to each other because they typically are both the result of a release. And so under Part 29, we're looking at primarily soil remediations, but if delineation for some reason shows that it has reached the Vado zone, has entered groundwater, then we're start to look at the broader rule of Part 30. And Part 30 definitions are based on water quality standards. So what that water quality standard is. From there, sorry, once it transitions, the goal kind of changes. So we're looking at soil remediation to full subsurface protection. With that subsurface protection, again, those specific contaminant levels are addressed under the the 2 stages of abatement plan. The primary goal of the stage 1 abatement plan is to investigate and delineate the release. That is kind of why it's written a little bit vaguely, because it is looking for that additional information. The stage 2 abatement plan is geared
Could I stop you right there for 1 second, Ms. Romero? The notice that is the subject of this hearing that Apache is objecting to, would you characterize that as a stage 1 notice?
It was a stage 1 notice, yes.
Okay, and I just wanted to be sure that that the hearing examiner understood that the notice they're disputing, the appeal they're doing, was based upon you're asking them to do a stage 1 abatement, correct?
Yes.
Okay, thank you. I'm sorry to interrupt you. Please
No
continue
problem.
with the framework.
With that, though, it kind of explains. Typically, we do see a lot of stage 1 and stage 2 plans come in together. Stage 2 plan is more about the remediation of the site, and we start looking at public notice and who needs to be notified of what we're finding in these scenarios. And so it is worded, and abatement is required because sometimes they do come in together, but stage 1 and stage 2 have those differences.
Now, forgive me if you said this, are there specific limits of, for instance, total dissolved solids or chlorides that are allowable in groundwater?
There are, and Part 30 actually refers to 20.6.2 standards. And so TDS is 10,000 and chlorides are typically around 250, I believe. I don't
And
have that rule up.
Well, at any rate, those allowable limits have been found to have been in excess by the testing that grew out of the OCC hearing last time, correct?
It does.
Okay.
So if I can continue a little bit. If the stage 1 plan, typically we do see a sample come back with contamination. The operator can voluntarily submit a stage 1 plan, or the department can send a notice to abate, a need to abate, which would be what this letter was.
And speaking of this letter, OCD considers Apache a responsible party or responsible person for the contamination, correct?
Yes. Both Part 2 and Part 29 have responsible person and responsible party definitions. There's anything in Part 30 that says we cannot use Part 29 definition or Part 30 definition. I'm sorry, Part 2 definition when we look at those things.
And 30 refers definitionally to 2 for responsibility, correct?
Yes, so it can either be the person causing the release or the person controlling the location of the release.
And 29 similarly, I believe you testified this case shifted from 29 to 30, the soil contamination to groundwater contamination, correct?
Yes.
Okay. And so now even in 2, does it say the owner and operator at right now, or at the current time, or does it say owner or operator?
Mr. Hall, you're getting into legal interpretation of the rules, and I would appreciate it if you don't ask her those questions.
I'm just asking what it says.
Yeah, I'd rather, the rule stands for itself. I'd rather just hear more about the case and less about how she interprets the rules. That's up to lawyers, I think. Okay. And you can make that argument in your closing argument. So.
Is there other background that you think would be helpful for the hearing examiner with regards to the general regulatory framework? Or are you prepared to speak more specifically about Apache's obligations?
I would like to just highlight 15.30.11, which I'm sorry, that is not the one I had up. I'm sorry. Yes, 30.11B. In the event of a transfer of ownership, control, or the possession of the facility for which an abatement plan is required or approved, where the transfer is the responsible person, the transferee shall also be considered a responsible person for the abatement or duration. Jointly share the responsibility to conduct the actions of 1530.
So to be clear, that explicitly says there can be more than one responsible party or person, correct?
It does.
Okay. Anything else about the general framework of how you make determinations before you send out an abatement notice?
In this scenario, I was very investigative. We did try to work collaboratively with Apache in order to prompt those investigations.
And based on those, the investigation, was much of that derived from reports Apache sent to OCD?
It was. So the existence of the groundwater contamination was confirmed. And since it was confirmed, OCD no longer considers it general regional activity in the same way as listed in some of these reports.
And so, I believe Mr. Graham's testified to this, and it's undisputed, there is contamination in excess of the allowable limits. And so, at that point, is there something else you do, or you ask a responsible party to abate it?
Well, again, this is where the request to abate has to do with actually investigating both the cause and the location. So we're looking for full delineation of what occurred.
And so, do you have a response to Apache's contention we heard today and in their pre-hearing statement that they're not a responsible person under the regulatory framework? Do you have a response to that?
It's my opinion that it would be inappropriate for OCD to allow an operator to divest, especially considering we have a commission order that was explicitly designed to investigate the contamination. And so the change of operator should not remove them from the obligation. They were the operator of record, not just for the EBDU 37 site, but for the entirety of that area surrounding where we're finding contamination for approximately 3 decades. So to me, saying that it's just because it's not in relation to that particular release is kind of a misinterpretation.
Is there anything in the regulatory framework that says OCD has to find out exactly when, where, how contamination occurred?
There's not.
Our job is to clean up these kinds of spills, correct? And protect the public from groundwater contamination?
Yes, it is.
And does the purpose of your notice to abate to Apache?
Yes, it was.
Is there anything else that you would like the hearing examiner to know about this matter or the general regulatory framework?
It's been mentioned several times that they no longer have access to the site. OCD would not recognize that as a reason to not continue the investigation at this point. The lack of ownership is not typically accepted by the department as a permanent defense against continuing with an abatement project. OCD would work within our legal ability to coordinate efforts between transferee and transferor.
Would there be a practical effect to if Apache successfully contends it's not a responsible party? What would be the practical effect of that on how we as regulators would be able to protect the public and deal with these sorts of contamination events?
I feel like that would be a very dangerous legal regulatory precedent to allow, allowing an operator to transfer away an asset for a site that is environmentally sensitive or has existing anything, especially in this scenario where we have an existing order, would be creating a large loophole for regulatory process.
I'll pass the witness.
Mr. Mullenberg?
Thank you, Mr. Examiner. Good afternoon, Ms. Romero.
Good afternoon.
I have just a few questions. Mr. Hall asked you if the March 12th notice letter, and tell me if I'm phrasing this wrong, was intended as a stage 1 letter. Do you recall that?
I do. I did review that stage 1 letter.
The March 12th letter, however, does not refer to stage 1 or distinguish between stage 1 and stage 2, does it?
It does not. As I stated earlier, sometimes they can come in together. The notice is purposely vague for all Part 30 is stage 1 and stage 2 plans. They can come in together, they can come in separately.
You were just speaking to the possibility that if OCD is not able to identify Apache as a responsible party and to require it to submit an abatement plan, that would be a problem. And I'm just giving you that for orientation here. But is there anything you're aware of that would prevent the division from sending a notice letter to the current owner and operator of the EBDU number 37 well and the associated unit?
As stated previously, all are considered responsible parties, and direct from Part 29, the division in its sole discretion may consider a person either causing the release or controlling the release a responsible party. The release was identified during Apache's tenure back in 2019. So that is why we have chosen to speak with Apache directly. That does not mean that any other operator may not be identified and receive notice. We would consider all to be responsible parties. However, none of those parties are parties to this case, so we're not discussing that too much.
Mr. Examiner, that's all I have.
All right. Mr. Hall, any redirect?
Just a couple. Ms. Romero, earlier, I might have been just confused, but I just want to clarify. You weren't speaking to an inability for operators to transfer assets, but you were concerned about passing the buck or transferring liability, correct? And then being OCD being unable to hold them accountable?
That's absolutely the concern. Um, as
Thank
this
you.
case is taken. Sorry, go ahead.
No, that's, if you have more to say, I wasn't trying to interrupt you. Okay, and just to be clear, the contamination was identified when, according to all parties, Apache was owner and operator of the relevant parcels, correct?
Yes, Apache was aware of the release since approximately 2019 when investigating the EBDU 37.
And I think, only one more question. Mr. Mullenberg asked you about your notice of abatement, and I just wanted to be able to pull that up so that we can look at that specifically. You do specifically say Apache must submit a complete stage 1 abatement plan within 60 days of this letter, correct?
It does say that.
And you give them the option to also do a stage 2 abatement plan, correct?
Yes, yes.
Okay. I just wanted the record to be clear on that. That's all of my redirect.
I have a question, Mr. Romero, because I'm not as versed in this case as you or Ms. Hall are. Can we remove that document from the screen? So I can see Ms. Romero. Thank you. So Mr. Romero, I'm very, this case is all new to me and I don't understand these regulations 29 and 30 like you do, obviously. What I'm wondering is from my perspective, it seems like this is what I understand so far, and tell me from your perspective what I'm missing here. The division identified, or it was reported that there was a produced water spill in 2019 while Apache was an operator in a particular area of New Mexico. Is that right?
Yes.
Okay. And then somehow, I don't know how, but somehow you got to the commission and you had a contested hearing at the commission. Were you involved with that?
I was.
Oh, you were? Okay. There was a contested hearing. The commission, I've read the order. I read the amended order. The commission ordered further investigation, further testing. And I believe one of the commission's findings was that it was unclear where this spill actually originated. Wasn't that part of the findings?
Yes, to some
Okay.
extent. Let me elaborate a little.
Sure.
When the release occurred, some contamination was suspected. There was a well very close proximity to where the release happened. And so that is why you see the note that came on the closure report that said this is for soil only and not for groundwater, the groundwater to continue to be monitored. At that time, we did not have the system we have in place now that would have more identifiable portions of that open and closure report. However, OCD continued to work with Apache to investigate what that looked like. When we went to hearing, OCD was pushing for a more aggressive investigation. We required a more complex set of monitoring wells in the suspicion that it possibly could be a different release that occurred. It was brought up several times during the previous hearing that was part of why we wanted additional monitoring wells to adequately identify where the contamination was. And so one of the intentions was for that more aggressive investigation to occur.
And Apache did not want to go along with that more aggressive investigation, and that's how you ended up in front of the commission?
Yes.
Okay, I understand. So there wasn't a hearing at the division level like there is today?
No.
Oh, interesting. And one of the things you said that caught my ear was you felt like there might be another release besides the one that was reported?
It was possible. It was something that was brought up by Apache during hearing.
Okay.
We did not contest that as we didn't have enough data to identify. That was one
Okay.
of the reasons we wanted a bunch more wells.
So the commission made its findings and in its order, it said, Apache, you're gonna do a bunch of more monitoring of groundwater. And in my own words, I don't know what it really said. And they've done that. And then the division got back involved, your bureau, I suspect, your bureau got more back involved, and you reviewed the groundwater data and you came up with a abatement plan based on the data that Apache gave you.
Apache's report did explicitly state that they believed it was from another release. We can confirm that groundwater was affected. That is why we start looking into Part 30 is once we have that confirmation, we can move into Part 30 at any point, but moving into Part 30 seemed because of the confirmed contamination.
Now Apache comes here to hearing and says, based on the data, they believe they're not the responsible party for that underground water contamination. Right?
Yes,
And that's it.
that's the case that as I understand it.
Yeah, no, I mean, that's how I understand it too. It's basically, it's not us, it's someone else. And then you showed me, you were talking about 30.12 in where, it said, not that it's your legal opinion, but that it said, the responsible party is not just one person, it could be more than one person. I read it myself while you were testifying. So the data that you're relying on, I mean, so is there data in the Apache report that makes you believe that it was from their control or operation that this occurred? Oh, you're muted somehow.
I don't know what I did there. Sorry. Brittany is going to go into a little bit more detail on this with some maps and some more specific identification. But yes, Apache has controlled the vast majority of the wells since the late 90s, I believe.
So Brittany will go into that more.
Yes, she's got some maps she'll be able to put on screen here.
About how the data ties to Apache.
Yes.
Okay, all right. I think that's a missing part for me. If that helps council know what questions to ask, because my reading of this rule, my reading of the 30, the part that you were discussing earlier, and let me find 12 again, abatement plan. This is the transfer of ownership that you were discussing earlier. it almost looks to me, and I don't have any authority for this opinion, but I'm just reading subsection B, that you were discussing earlier. It looks to me as though if there is an abatement plan in effect when there's a transfer of ownership, blah, blah, blah. And I think Apache is contesting the abatement plan, and I don't know how this would apply in that situation. So that might be something for closing arguments to discuss, and help me understand how it all ties together. I don't have any other questions. Thank you, Ms. Romero. May this witness be excused, Mr. Hall?
Certainly.
Thank you.
Uh,
Thank you, Ms.
Can I ask questions?
Let me think for a minute. Do you work under Ms. Romero?
Ms. Romero is my supervisor, yes.
I'll allow it if there's no objection. Is there any objection?
Interesting question. And particularly having a technical examiner in that position, but it's probably not the first time. I won't object.
Okay. I mean, you can object if there's a question that you feel is outside the scope or whatever. So go ahead, Mr. Smith.
Thank you. Mr. Romero, obviously not a legal opinion, but wouldn't you agree that it's the OCD's responsibility to oversee the remediation of soil and groundwater for reported and unreported releases that involve oil, gas, produced water, and other oil field wastes?
Yes, that is the intended goal of our rules. The objective.
I mean, and generally speaking, how does the OCD handle historic releases that may have been unreported that were discovered by a reportable spill in the past?
Typically, we would want them reported at the time of discovery. This is why the 2019 dates are so important. Was aware of a release occurring at some point in 2019, whether it is this specific release that caused it, but when there was suspicion of an additional release, that likely should have been reported and separately under our system.
So you wouldn't say Apache OCD's handling of the case was outside the norm of what OCD normally does?
No. Typically, even in the scenario of the pit, if contamination is discovered on a site while investigating something else, typically the operator of record is responsible for remediation. I would go so far as to point out that OCD on remediation sites in which we've encountered pits, we've also done remediation of those sites.
And again, generally speaking, when handling site investigations for most spills that OCD handle, right, are soil spills.
Most are soil spills.
Would you, when operators are investigating those spills and they discover groundwater, do you think is it unusual for operators to install multiple groundwater monitoring wells before they move to Part 30?
It is.
Mr. Hearing Examiner, I think we're getting into hypotheticals that do kind of get outside what we're focused on in this case here. So I would object at this point.
Mr. Smith, where are you going with these questions?
I'm just asking Mrs. Romero if the way the OCD handled this case is abnormal in moving it to Part 30.
I don't think that's an area that's really in contention. I think it's quite clear that the division feels it's appropriate to move from 29 to 30 based on the data that was reported from the well monitoring program that Apache was required to produce. So do you still feel like there's a gray area here for you to elicit information?
Let me just read re-ask this question. Ms. Romero, do you think the OCD could have sent the abatement request letter years ago?
We could have. We were sort of operating under a collaborative approach prior to.
I don't have any other questions. Thank you, Ms. Romero.
Ms. Romero, when you say collaborative, do you mean between Apache and the division?
Yes.
I thought that's what you meant, but I just wanted to be clear. Thank you. May this witness be excused?
Yes.
Thank you. Ms. Romero, thank you.
Yeah.
Ms. Hall?
Yes, sir.
Okay, thank you. I remind you that you're under oath. Mr. Hall?
Thank you. Could you state your name, please, ma'am?
My name is Brittany Hall.
How are you employed, Ms. Hall?
I am the Environmental Field Compliance Supervisor for the Oil Conservation Division.
And how long have you held that role with OCD?
A little over a year.
And as I believe I'm getting your two CVs mixed up. Yours is, I believe, Exhibit L. Does that more, it's been admitted, does that more thoroughly lay out your professional history?
It does.
And is that a true and correct copy of your CV?
It is.
Okay. I kind of want to go through, I guess, in my opinion, Mr. Romero gave a little bit of a broader view of the regulation and the regulatory framework. That's a generalization, but that's my predicate to this question. Have you had a chance to review specific data provided by Apache or through your own investigation relating to this case?
Yes, I have.
Okay, and I'm gonna move, give me a second. These exhibits are kind of voluminous. Okay. My esteemed second chair today is helping me with my computer skills. I learned about bookmarks just now. Okay, I'm moving to Exhibit E. And I'm going to try to share that. Okay, so there you see Exhibit E. I'm gonna kind of scroll down. Do I need to zoom in a little on that?
I'm not sure if everybody in the room can see it, but I also have the exhibits open on my end, so.
Okay, you're familiar with this document?
Yes, sir.
And what is this?
This is a table that I created. I pulled the table that Apache provided in their field activity report that was submitted after the commission granted the final order, and I added additional data that was submitted to the OCD in May of this year. Those are the yellow highlighted areas. Those are data that I pulled from Apache's lab reports that they submitted through our online permitting portal and added them to a previous table that Apache had provided in the report.
Okay, thank you for that. What, if you could help the hearing examiner understand the significance of this document? What is it you would like him to understand from this?
Yeah, the significance of this document basically shows the history of the groundwater contamination since the date of discovery when the wells were installed in 2019 all the way through what Apache had drilled and installed in 2025, I believe, is when the last well was installed. I may be missing a date, maybe 2026, but it really just shows the history of when the groundwater contamination was discovered all the way through Apache's current activities at the site.
And so, oh, go ahead. I'm sorry. I wasn't trying to interrupt you.
I was also just going to mention that it obviously shows, the different analytical results through the lifetime of the monitoring at the site as well.
And these test results came at different times, correct? Some started later, some started earlier.
Correct. The older wells will have more data than the newer wells.
Let's look, for instance, at TMW2. Did Apache own and operate and have custody of the location in 2019?
Yes.
Does that indicate contamination in excess of the allowable levels at that time?
In TMW2, yes.
Okay. And I believe, I don't know if you heard earlier, they testified that they sold this property to Hillcorp in 2024 or 2025. Did you hear that?
I did.
So all of these results before that show dangerous levels of groundwater contamination, correct?
I think dangerous is a subjective word, but it does show contamination above allowable limits.
The limits are there for a reason, correct?
Correct.
There's reason for concern when they go above that amount. Would you agree with that?
Yes.
Okay. And so, not to belabor the point, but there's a multitude of samples showing during Apache's custody, control, ownership, and operatorship of this location, there was groundwater contamination.
Yes, and I should probably clarify that the blue highlighted results are Apache's way of indicating that those results were above the limits. The ones in yellow, I have made the text red to indicate that those are above the allowable limits.
Because yellow shows these recent testing results and red indicates those are in excess of allowable limits. Did I characterize that right?
Correct. The yellow is what I added to the table, as Apache did not supply a table with these results on it.
Okay. Is there anything else we should discuss about this particular exhibit?
I think everything has been hit in previous testimony.
Okay. I'm going to just stop sharing for 1 second and try my bookmark trick again. And I'm going to go on to exhibit F, which let me try to share that now. Okay. Are you seeing that, Ms. Hall?
Yes, sir.
Okay. And certainly just tell me, this is a really long exhibit, isn't it?
It is a very, very long exhibit.
What is this?
So this is the field activity report that Apache submitted after they completed all of the required actions from the OCC order.
Okay. And so I won't ask you to go in depth about it, but I will ask, is there anything that hasn't been covered or otherwise that you would like, that you think is relevant evidence to be considered in this exhibit?
Yes, would you scroll to page 67 of the PDF? I don't know what number it is.
Sure. Let me close this bookmark. Okay. Page 67. Did I hear you correctly? Okay.
Yes.
Give me 1 second. Or maybe I can do this. Is that what you're looking for?
No.
Okay.
If you'll scroll up 1 page about halfway right before it says 6.0 recommendations.
Let's say 66, so we were close. That page?
Yes, sir.
Okay. Oh, sorry, that page?
Nope, you're on the right one.
No, I know, I'm sorry. Okay, there we go. Can you see that or should I zoom in?
If you wanted to zoom in just a little bit.
And it's the bottom part in particular that you're wanting
Yes.
to discuss? Okay.
Yes. And just right above that 6.0
Oh,
recommendation
sure.
section.
Soil boring or even higher?
Right there's perfect.
Okay,
And
Please-
I think
please, go ahead. Please continue.
it's been discussed in previous testimony by Apache's expert witness that the soil boring 2 is an area that is a source that likely impacts groundwater. As you read further down through the recommendations, Apache is recommending to develop and submit a semi-annual groundwater monitoring report, and groundwater monitoring reports are part of a stage 1 abatement plan, which is why we felt it was necessary to roll Apache into a stage 1 and or a stage 2 abatement plan. So those are really all that I needed to point out in this exhibit.
So, thank you for that. Okay, I'm now going to go to, sorry here. That's not it. Okay. Yeah, I'm gonna now go to Exhibit G, which, if you could tell, well, I'll go down a little more so you can, and let me share it. Okay, I'll go down so you can know what this is. Let me zoom in. Do you recognize that, Ms. Hall?
I do.
And what is that?
It is a timeline of events that happened after the OCC granted the final motion, including dates of emails that I received by Apache's contractor. Those emails included, requests to adjust some of the well locations due to safety concerns, whether those were overhead power lines, pipelines, flow lines, overhead electrical lines, fencing, and also emails that Apache's contractor had sent me after they received the lab reports, whether that be soil data or groundwater data. And then it further goes on to, include OCD's approval of the transfer from Apache to Hillcorp, and when we have received additional reports submitted through OCD permitting.
Okay, and more specifically and it's okay if there isn't, is there anything in particular that you would, other than just a general overview of the back and forth and the timeline of things, is there anything specific in there that you would like the hearing examiner to focus on?
I would like to point out that Apache has continued work at the site even after Hillcorp has taken operatorship of the site.
Anything else?
I don't believe so.
Okay. Oh, let's see, I need to do differently. We resubmitted that. Let me find that one. I apologize. I think this is the proper one. Let me share. Do you recall Exhibit I, or do you need me to pull it up? I wouldn't recall it if I didn't see it.
If you'll pull it up, I think I have a.
Sure. I sure will. Give me 1 second here. Does it? Okay, I'm zoom in, but does that look like Exhibit I? Well, I went too far. Exhibit I to you?
I believe so.
And what is this?
This is a table I created based on the history of well ownership for every I don't want to say every well in the area of the release, a good chunk of the wells in the release, just showing, you know, either when Apache acquired that well from a different operator, or if Apache drilled that well after they had already taken ownership of the unit.
Okay. And do you, are we going to look at a map a little bit later that also shows some that would work in conjunction with this document?
Yes.
Oh, is there anything in particular you want to point out with this, or should I move on?
I think you can probably move on.
Okay. Okay, I'm going to move to Exhibit J. And ask you to identify that. Oh, wait, sorry. Let's get to the substance of it. Can you see that, Ms. Hall, or should I zoom in?
I can see it.
Okay, what is that?
This is a table that Apache submitted for the groundwater monitoring that they did after all of the new wells required by the OCC were completed. So there was a groundwater monitoring event in August, right after the OCC order, and after all the wells were drilled, and then they have continued to monitor. So this includes the monitoring from the fourth quarter. Since they installed the wells during the third quarter, they sampled during the third quarter. This is the information that was provided to the OCD when they sampled all the wells during the fourth quarter. It's just showing that Apache has continued to perform activities after the site, at the site, after Hillcorp has taken possession of the area.
Okay. Anything else? I'm kind of just scrolling through it, so.
No,
So
it's a
people are
lot of numbers and a lot of lab reports.
Okay. Anything else you would like to point out about this particular exhibit?
No.
Okay. Let's see how many. Okay. Stop sharing. All right. Now I'm going to move on to exhibit. Wait, where's the map?
I believe the map was exhibit H.
H. I'm sorry if I skipped over that. Okay. Let me, okay, I have it. Let me share it. Okay. Tell me please if you need me to zoom in, zoom out, etc.
Might be easier to zoom in just to get a little bit of the color differentials to pop a little better.
Okay. And I can move around as needed.
I think
Mr. Hall, I'm sorry, Ms. Hall. Mr. Hall, while you're doing this, let me just say that I need to break in 20 minutes.
Okay.
Now, the OCD has as much time as it wants to put on its case, but we just have to break in 20 minutes.
Fair enough. I'm almost done.
Oh, you are?
Yes.
But I'm assuming that Mr. Hall will have questions, maybe even Mr. Smith might have questions. I don't know, but I'm assuming that they will. So just in case, I just want to have a plan B here in case we go over 20 minutes.
Okay.
Would the parties prefer to reconvene tomorrow virtually, not in this room, or would they prefer to reconvene on Monday in this room?
Highly prefer tomorrow, as I have a field visit Monday. I would really be unable to attend Monday.
Okay, you have co-counsel, of course. However, I get the point.
He's also going to be in the field.
Oh,
Tomorrow's my day
Okay.
off, so give me some credit for that.
sounds good. Monday was my day off, so I was gonna come back for that as well. Mr. Molenberg, it sounds like that tomorrow works for one party. Does it work for you?
Mr. Examiner, I believe it does, and that's assuming we can't actually finish the testimony at least this afternoon. I mean, I think that is a possibility even within 20 minutes. I would, however, suggest that perhaps rather than doing oral closing statements.
I wasn't thinking of that.
Okay,
So
because
don't
I was,
worry.
yeah, I was going to suggest written closing
We're definitely
statements.
doing written. We're
Okay,
also doing proposed findings and conclusions. However, we haven't gotten there yet. So-
got it, got it.
So that being said, you would prefer tomorrow. That's fine. It would be virtual for everyone. No one would come back to this room. So at least we have a plan B. 9 o'clock,
That works for me.
Mr. Molenberg.
That will work. Yes, thank
All
you.
right. And Miss Hall, would that work for you tomorrow?
Yes, it would.
And Mr. Smith?
That works for me as well.
All right. Then why don't you continue? But at 20 after, we're going to break. So go ahead.
Okay, thank you. Ms. Hall, we're looking here at the map, which I think is Exhibit H. If you could just walk us through this and let the hearing examiner know the significance of this.
So this map I created based off of that Exhibit I, showing all of the history of ownership of the wells. The wells that are in orange are wells that Apache drilled after they obtained ownership of the area. The wells with the red squares on them are wells that Apache had purchased from a previous operator. And there's a few green wells on there that Apache has never owned or operated, didn't drill, has nothing to do with them. There is a purple star that indicates a facility that is registered with the OCD that is still in our records owned by Apache. And then the purple box is a very rough estimate of the area that Apache has done investigations due to the release that occurred in 2019 and any additional directive given either by the OCD or OCC. I kept it primarily for looking at up-gradient wells. Obviously, there's a lot more wells to the north of this area, but Apache has either purchased the wells and have operated the wells or drilled the wells themselves. So if there's any up-gradient contamination that could be migrating onto the site, Apache had ownership of those wells at one point. Obviously, we've heard testimony about the red beds potentially affecting things in a different way. That pit is indicated on the map. You can actually see it. It's just northeast of the well at the very bottom of the purple circle. And so when the contamination was discovered, Apache did have ownership and control of the area.
Okay, thank you for that. Anything else related to this exhibit that you would like to express?
No, sir.
Anything else generally that you want to say about this case to the hearing examiner?
I don't think so.
Okay, I'll pass the witness.
Mr. Molenberg.
Thank you, Mr. Examiner. Ms. Hall, Mr. Hall asked you a question about, I think he used the word dangerous in reference to groundwater contamination. Do you recall that?
Yes, I do.
And I think you maybe were careful in your answer already, but are you familiar with the groundwater standards in 20.6.2.1203, which are referenced in Part 30, the abatement rules?
Yes, we typically call it the 3103 table.
Right. And in that table, are there separate categories for different kind of standards? For example, human health standards?
There are.
And is chloride does it have a human health standard?
It does not.
Excuse me, Mr. Examiner, I thought I had one other question, but perhaps I do not.
Take your time.
I believe that's it.
All right, thank you.
I have
Mr.
one follow-up based on that.
I'm not done, Mr.
Oh, sure.
Mr. Smith, questions?
Um, I guess, I mean, it is relevant. I feel like this is relevant to ask. Ms. Hall, based off of your CV and your experience, you've worked with operators, multiple of operators, and have been regulated by OCD staff, OCD rules, I should say, right? Not staff.
Correct.
And these rules in particular.
Correct.
Over your experience, how have you, or just high brief opinion, how have other operators in the OCD handled historic or unreported releases in the past?
In my professional experience as a consultant, if I was working for an operator and they discovered contamination that was not necessarily part of what they believed their release caused, it was still reported by them to the OCD.
And it was cleaned up typically by them?
Correct.
Would you also agree that during your time that as a consultant or as an OCD employee, that doing investigations, installing monitoring wells, collecting groundwater samples and soil samples typically occurs before the issuance of a formal abatement letter?
I would say no. Generally, once a release is discovered to impact groundwater, generally that is rolled right into Part 30, and any activities performed after that is performed under the abatement plan.
Okay. And then recall very really quick, you did review Apache's field activity report, and I'm positive because you've kind of went through this with both of your attachments. Based off of your experience and your professional opinion, there are elevated levels of contaminants in the groundwater at or near the release site?
Yes.
I don't have any further questions,
Right.
Mr.
Mr.
Tequila.
Hall, redirect.
I think Mr. Smith hit it, but chlorides are considered a contaminant to groundwater in excess in the amounts that were found by the testing in this case, correct?
Yes, they are a contaminant of concern.
Okay. As are total dissolved solids?
Yes.
Thank you. I'll pass the witness.
All right. May this witness be excused?
Yes.
All right, thank you. Does that conclude the case in chief for the OCD?
Yes.
All right, sounds good. Mr. Molenberg, anything else evidentiary wise before we go to post-hearing pleadings?
No, nothing from us.
All right, from the division?
No.
All right, very good. I've been doing some research and I need something to be briefed in the closing arguments, okay? I'll state it here on the record. I can also send this in an email as well. We need to determine length of closing arguments, citations, and we need to discuss proposed findings of fact and conclusions of law. But the legal question that I need answered, including authority, if you have any, is the following. Under 1915-29 and 1915-30 NMAC, who is the responsible party when groundwater contamination in excess of the standards is detected at or near a site where an operator conducts oil and gas activities? The party's brief should address the legal definition of a responsible party under 1915-2, under 1915-29, release and reporting and remediation, and under 1915-30, abatement. B, whether the division must identify the exact source or specific release causing groundwater exceedances before requiring abatement, or whether the operator of record is responsible as a matter of law when contamination occurs at a site under its control. C, whether the presence of historic or legacy contamination on an oil and gas site alters the responsible party analysis under the rules. And finally, whether an operator's assertion that a particular incident, for example, the 2019 release, did not create the plume, is legally sufficient to avoid responsibility for abatement under 1915-30. Those are the legal questions that I need answered. And I will send an email to the parties with this, so you do not have to try to copy every word I just said. I have it here in an outline format. Okay, with that being said, let's talk about the transcript. So we have two records. We're going to have the recording, which will be an audio visual recording. We will also have an AI transcript, which can be very helpful at pointing to a spot on the recording. It may not be perfect in its transcription, but neither is the verbatim transcripts that we have court reporters do either. So this is what we have. They will be available almost instantaneously. Freya, when is the AI transcript and the recording available?
They'll be available tomorrow.
That's what I thought. Okay, so that won't delay anyone. And I'm not rushing anyone. I'm just letting you know when things will be available. I've given you the legal matter to brief and broken it down into 4 parts. When it comes to closing arguments, how many pages of a limit do the parties think is reasonable? I'll start with you because you're the petitioner, Mr. Mullenberg.
I'm sure we can do it in 10 to 15. I haven't considered how the specific questions you asked fit in, but I think that's fine.
Okay, 10 to 15 makes sense to you, Mr. Hall?
I think so. Does that would include closing, findings of fact, conclusions of
No.
law, and a brief on these questions?
Definitely not. This is just a legal closing argument with authority. This is the critical question in my mind, is what I just read out loud. Because ultimately, petitioner is saying, hey, it wasn't us. The plume is, we're not responsible for the plume. Sure, we may have been responsible for the spill. We reported it, we cleaned it up, but we're not responsible for the plume. However, the way I read the law, I'm not so sure that's the correct interpretation of the law. And I'm sure you don't agree with that interpretation. So that's why I need a legal brief.
Certainly. No, I was just making sure.
Of course.
That sounded, I was going to have to single
Yeah,
space.
no.
Okay, that.
In
10
5,
to 15 sounds good.
just for the closing argument, and the closing argument must revolve around this legal question to be briefed. Okay, really, that's the crux of the matter here.
I agree.
All right, fine. So you agree, Mr. Mullenberg?
Yeah, and I think we're on the understanding. My understanding is that the legal brief would be part of the closing statement.
Part of it.
Okay, yeah, that's what I thought. We're not talking about 2 separate
We're not.
documents. Okay,
We're not.
we're on board.
We're
then,
not.
Yeah.
That's correct. Obviously, the legal brief is the center, is the core of any closing argument, because that's the issue that we're here to decide. Really, that's the
Right.
bottom line issue.
Yeah.
Okay. Then when it comes to proposed findings of fact and conclusions of law. I'm not going to put a page limit on it, Mr. Hall, Mr. Mullenberg. That's too fussy for me. However, any proposed finding of fact must cite either to the transcript or to an exhibit, because it's been admitted. We have 3,000 pages. That gives you plenty of room to cite to whatever you want to cite. But please, please cite to anything, because if you have a proposed finding and there's no citation to it, I'm not going to consider it. I won't even consider it. Okay. And obviously your conclusions of law should also, be centered around this critical legal question that I've asked for a briefing on. With that said, and does that sound fair to both parties?
Yeah.
All right.
It does.
Good. With that said, and Mr. Mullenberg, I'll have Freya email you this language in the briefing, the legal issue briefing, along to Mr. Hall and Mr. Tremaine later or tomorrow morning. With that said, how long do parties want to submit the closing argument and the proposed findings and conclusions? I'll start with you, Mr. Mullenberg.
Yeah, Mr. Hearing Examiner, I'd actually ask for 3 weeks.
Okay.
Normally, I would say less, but starting Monday, I'm going to be in a hearing for 2 weeks in front of the Water Quality Control Commission. So
I'm not rushing you.
okay.
You can suggest a month. If you really want a month, you can suggest a month. I don't know what Mr. Hall will say, but you can have what you want. But 3 weeks?
3 weeks is good for
3
me.
weeks.
I mean, that'll get us done before the July 4th holidays.
Okay. Mr. Hall.
I also am obligated at the Water
Right.
Quality Commission.
Right, you are.
I would like a chance for Mr. Tremaine and I both to deal with this after that. And so I would really ask for slightly more time, 4 to 5 weeks. If that pleases you, that we could do it within that time frame.
To be fair, Mr. Mullen, and you're the one who has the burden of proof,
Mhm.
so, giving you more time may benefit you. I don't know, but to be fair, I know Mr. Hall is going to be tied up for the next 2 weeks. Now, if I were Mr. Hall, I'd want something else to do while I'm sitting there listening to this testimony that.
Close
Oh,
attention.
no, he has to pay attention.
Oh, yeah, right, okay. But still, he's asking for 4 to 5 weeks. Do you have any preference over 4 to 5 weeks?
No, I
You
don't have a
care.
preference
So
either way.
5
Yeah.
weeks is fine with you?
Yeah, that's fine.
What's the date?
That's a good question.
Mr. Tremaine's looking.
Lucky he's here.
Huh.
Lucky he's here to back you up.
No, yeah, obviously my technological skills are off the charts.
July 10.
July 10? And that's what, a Thursday?
That's a Friday, so I jumped it to the end of the
You
week.
You did. You added
Yeah, I
another
have
day.
5 weeks in a day.
You took a little leeway there. So what is it again, please?
It's July 10.
July 10. So Mr. Mullenberg, July 10 is the deadline. Now, that gives you plenty of time to exchange your proposed findings and conclusions to see if a party objects to something that's in there, because you might have an objection that, hey, this isn't part of the record, or this, whatever it may be. I'm going to ask the parties to exchange their proposed findings and conclusions in case there's some objection to something that's included there. I will then take 2 weeks to come up with a report and a recommended order for the director to review and either sign or tell me no, he doesn't like it and he wants something else. So that being said, I'm going to reserve 2 weeks for myself.
Just one other question for clarification, and I think this probably goes without saying, but I think you identified 4 topics for legal briefing.
I did.
We're happy to brief those, but we're not limited to those, correct?
Your closing argument can go anywhere where you want it
Right.
to go.
Yeah.
The legal briefing that I want, it really isn't 4 issues. It's one issue broken down into 4 subparts.
Right.
I was just trying to be clear. based on my research and based on the branches of the question of responsible party under different parts of the rule, et cetera, but I will email it to you and to Mr. Hall and Mr. Tremaine. And if you have some objection to what I'm asking for, feel free to let me know what that is. But this I feel is the critical issue here.
And I don't disagree with that at all. I'm just clarifying that
Sure.
we're not limited to that, as long as we address those issues. If
Your
we-
legal
I-
briefing
yeah.
can be part of your closing argument. It doesn't have to be the whole closing argument. Do you understand what I'm saying?
I understand what you're saying. I'm just,
Yeah.
if there's legal issues outside the four or the whatever, we just, that's
You're
fair
here
game. Yeah,
You're here to do the best job for your client as you can. and
Understood,
You
yeah.
do it as you see fit. I'm certainly not here to tell you how to represent your client, but this is something I feel like I need to understand fully. Mr. Hall.
This is a stupid question. I acknowledge it, but I want to be sure no one has to be here at 9 a.m.
Definitely.
okay.
We're done.
All right.
We're-
I was asking that mainly for Miss Hall's benefit.
By all means.
Okay, thank you.
We're done. We're off the record.
great.
Thank you.